This video is about employee handbooks and policy manuals that the employer provides to employees. And these handbooks and policy manuals cover a lot of things. They cover what sort of behavior is expected from employees, what sort of things they can be disciplined for, how the discipline system works. It may provide for things like wages and vacations and sick leave, and the list just goes on and on. These could be very short, they could be very long. The big question that arises in a lot of lawsuits is whether or not the provisions in the policy manual or the employee handbook is actually part of a contract between the employer and the employee. If it is a contract, then each side can enforce the provisions that are favorable to them. If it's not a contract, then it's really just a statement of policy, a statement of intention, but not really legally enforceable. In order for a handbook or policy manual to be a contract, you basically need three things. First of all, you need an offer. And the offer would normally come from the employer. Here, I'm offering you this policy manual. Maybe it's printed out and handed off. Maybe it's on a website, and the employee is invited to go click on a link to read it. And secondly, you need to find that the employee has accepted the offer. The employee has made some indication, yeah, okay, I'll go with this employee handbook. And oftentimes just the mere fact that the employee has gone to work or continued to go to work is an indication that the employee has accepted the offer. The third thing you need is what lawyers call consideration, which means if the employee wants that policy manual to provide something for the employee must have provided something for the employer. And oftentimes, a court will say, well, just the fact that the employee went to work or continued to go to work provides the consideration that is necessary. Now, employers have been litigating employee handbooks for many years, and one of the things they often do is put in the employee handbook a disclaimer, which simply says, hey, this manual is not a contract. It is not intended to create a contract. This is all a matter of state law, so we get different interpretations from one state to another. But some states will simply say, oh, okay, that's what it says, that's what it means. And some states will say, well, but if that's hidden away and it's not put in a conspicuous place with maybe larger type, then the court's going to ignore that disclaimer and go ahead and make that handbook a part of the employee-employer contract. So be careful. This is all a matter of state law. There are 50 states, so you're going to get somewhere around 50 different answers to most of the questions. And the local employment lawyers will probably know the right answer. Thank you for watching.